Hello everyone, welcome to Islamic Law Lectures. I'm Marjina Sultana, an assistant professor from International Law College, Greater Noida. Today, we will discuss secondary sources of Muslim law. Customs or Urf Tasmul ul Adat was never formally recognized as a source of Muslim law, though it has been occasionally referred to as supplementing the law. The Muslim law includes many rules of pre-Islamic customary law which have been embodied in it by express or implied recognition. Before Islam, Arabs were governed by customary laws. Most of the customs were abolished by advent of Islam, but those customs on which Prophet Muhammad, peace be upon him, remained silent were allowed to proceed. It is never formally recognized as an authenticated source of Islamic law. It does not command any spiritual authority. There are some requirements or essentials of a valid custom. Firstly, general prevalence in the country is necessary. So, the practice of limited number of individuals cannot be recognized as custom. Secondly, it must at least be territorial, if not universal. Thirdly, it need not be existing from the time of the Prophet Muhammad, peace be upon him, or his companions. Fourthly, it must be ancient and invariable. And lastly, it should not be opposed to public policy. Section 2 of the Shariat Act 1937 has abrogated customs and usage insofar as they had displaced the rules of Muslim law. This act is applicable to every Muslim irrespective of the school to which he or she belongs. But in some matters, a Muslim is still governed by customary law. In agricultural land, testamentary succession in certain communities, and charities other than wakfs. The next secondary sources of Muslim law is judicial decisions. The decision of the Privy Councils, the Supreme Court, as well as of the High Courts in India are regarded as precedents for future cases and becomes an authority for subsequent cases arising in subordinate courts. On some points, the judicial decisions have completely modified the pure Muslim law. For example, under the pure Muslim law, no interest is allowed on a loan. But in Hamira Bibi versus Zubaydah Bibi, the Privy Council allowed interest on the amount of unpaid dower. In Muhammad Ahmad Khan versus Shah Banu Begum, maintenance under Section 125 CRPC, in addition to personal laws, were allowed. In Sarla Mudgal case and in Lily Thomas versus Union of India, the Supreme Court directed that the malified second marriage will be considered as committing fraud on religion. Its validity is challengeable in court under Section 494 of IPC. Muslims in India are also governed by various legislations passed by the various legislators or parliament from time to time. For example, the Muslim Personal Law Shariat Application Act of 1937, the Solution of Muslim Marriage Act 1939, the Waqf Act 1954, Criminal Procedure Code of 1973, the Muslim Women Protection of Rights and Marriage Act 2019. Under Muslim law, the principles of justice, equity, and the good conscience can also be regarded as one of the sources of Muslim law. This justice, equity, and the good conscience is based on the public utility, based on the public good, or we can say juristic equity. So these the rules of equity and equitable considerations are not something foreign to Muslim system, Muslim legal system, but in fact it is often referred to and invoked in the adjudication of cases. Imam Abu Hanifa, who is the founder of the Hanafi school of law, expounded the principle that the rule of law based on analogy could be set aside at the option of the judge on a liberal construction or juristic preference to meet the requirements of a particular case. These principles of Muslim law are known as istihsan or juristic equity. Istihsan, in its literal sense, it means to consider something good, but it can be translated as liberal construction or juristic preference. Imam Abu Hanifa, who was a great jurist, used the term istihsan to express the liberty that he assumed of laying down the law, which is his discretion, the special circumstances when the special circumstances required, rather than law which analogy indicated. This means that he used station for the use of juristic equity in special circumstances as opposed to the analogy, that is the qiyas in Arabic. So station means using of juristic equity instead of analogy. But this use of station was not accepted by his colleague Malik ibn Anas. Malik ibn Anas felt the necessity of some surer test for the development of law on right lines, but he considered that the introduction of station uh, uh, was was open to grave objections. With the aim of reconciling these two opposing factors, he proposed the use of istisla. Opposing factor because he felt that uh, by using station, we are applying, we are not referring to the Quran and religion, but to external circumstances independent of Islam. So he opposed the use of istihsan and proposed istisla to be used. It means istisla means seeking peace or amending. Thus, Imam Malik, Imam Malik invented the doctrine of istisla, means public good, this which is a process similar to istihsan. He also uh, invented another method, a distinct method of juristic interpretation known as istidlal. So here the talking about juristic equity, public good, or istidlal, which is the interpretation, a method, a way of interpreting laws. So this development of law by istidlal and istidlal, Istidlal, oh my god, it's so complicated. Istidlal represents the period of juristic equity in Muslim law. So the importance of justice, equity, and good conscience as a source of Muslim law was well assessed the by the Amir Ali. Here I'm not going to mention his assessment, but the object we can the object of istisla or istihsan is to avoid the rigidity and inflexibility from literal enforcement of certain ruling. Thank you.